Welcome to Lecture 9 in this series on critical reflections on the EU's data protection regime. Katherine Nolan's chapter asks a deceptively simple question. What does lawful data processing require when the GDPR is only one part of the legal framework? The answer is that data protection now operates inside a dense regulatory ecology. The ePrivacy rules, competition and consumer law, the Digital Markets Act, the Digital Services Act, the Data Governance Act, the Data Act, and sector-specific duties may all touch the same processing operation. The chapter therefore moves beyond a siloed reading of the GDPR and examines how overlapping laws justify, constrain, and sometimes destabilize data use. The GDPR remains the starting point because its material and personal scope reaches a large proportion of contemporary data processing. Yet compliance with the regulation does not settle legality. Another law may require data to be collected, disclosed, or retained. A specialized regime may impose additional transparency or portability duties. Competition or consumer law may condemn a practice that appears formally compatible with data protection rules. Nolan's central claim is methodological. Lawyers, controllers, and regulators must analyze the full legal system around a processing operation. No instrument applies in a vacuum, and the legal answer can change once the surrounding regulatory obligations and objectives enter the analysis. The chapter calls legislation that requires processing mandating legislation. It can interact with the GDPR through two principal routes. First, Article 6, subsection 1, subsection C, and 6, subsection 1, subsection E allow processing where it is necessary to comply with a legal obligation or necessary for a task in the public interest or the exercise of official authority. Second, Article 23 permits union or member state law to restrict selected GDPR rights and duties for specified objectives. Neither route creates a blank check. The mandate must be sufficiently clear, the processing must remain necessary, and Article 23 restrictions must define their purpose, scope, and safeguards while respecting the essence of fundamental rights and the principle of proportionality. A statutory mandate may establish a formal legal basis, but the inquiry continues. Articles 7 and 8 of the Charter place the mandating law under a second tier of scrutiny. They work in two ways. As interpretive standards, they require other legislation to be read so that it strikes a fair balance between competing rights and interests. As grounds of review, they permit courts to narrow or invalidate measures whose data processing demands go beyond what is strictly necessary. The chapter traces this discipline across copyright, customs, anti-money laundering, passenger data, and surveillance cases. The consistent point is constitutional. Nominal compliance with another law cannot immunize processing from rights review. The hardest cases often place privacy and data protection against public access to information. Search listing litigation has generally given data protection substantial weight, although through contextual balancing. The tension becomes sharper in anti-corruption and anti-money laundering regimes. In OT, the court accepted the importance of combating corruption, but found aspects of a public register disproportionate, particularly where information about partners and family members became public. In Luxembourg business registers, general public access to beneficial ownership data created a particularly serious interference. Nolan's concern is that these cases tend to frame an individual right against the general public interest without developing a coherent account of data protection's own societal purpose. Earlier EU data laws often divided their scopes more clearly. The Law Enforcement Directive governs designated law enforcement processing. The EU institutions regime applies to union bodies, and the non-personal data regulation contains an express division for mixed datasets. The newer digital acquis is less tidy. The Digital Markets Act, the Digital Services Act, the NIS2, the Data Governance Act, the Data Act, and proposed sectoral instruments commonly state that they apply without prejudice to the GDPR. That phrase, without prejudice, preserves the GDPR formally, but it does not explain how overlapping duties, borrowed concepts, and distinct regulators should operate together. The result is a thicket of obligations rather than a stable hierarchy of rules. Nolan identifies several recurring forms of overlap. First, complementary duties may pursue related objectives while differing in scope, legal basis, and operational design, as with the Digital Market Act's portability obligations and Article 20 of the GDPR. Second, instruments borrow GDPR concepts, especially consent, while adding their own conditions and purposes. Third, legal basis ambiguity arises where a new law appears to require processing, but denies or fails to clarify whether it supplies an Article 6 basis. Fourth, regulatory coordination becomes unavoidable because data protection authorities, competition bodies, platform regulators, and sectoral supervisors may examine connected conduct. These overlaps generate compliance costs, litigation incentives, and opportunities for regulated actors to exploit uncertainty. The doctrine of lex specialis gives priority to a more specific rule over a general one and can resolve some technical conflicts. The ePrivacy Directive illustrates this point. Its rule for storing or accessing information on a device may displace the GDPR on that specific issue without displacing the GDPR for subsequent processing. The doctrine becomes far less useful when the conflict concerns normative objectives rather than drafting detail. A law promoting data access, contestability, or monetization may pool against a law protecting individual control and fundamental rights. Calling one instrument more specific does not decide which social objective should prevail. That task requires interpretation, constitutional balancing, and institutional judgment. The chapter's prescription is proactive reconciliation. Legislators should specify legal bases, relationships, and conflict rules instead of relying on without prejudice clauses. Regulators should coordinate guidance, supervision, and remedies across functionally connected regimes. Courts should interpret overlaps through Articles 7, 8, 52 of the Charter. Regulated organizations still need to operationalize both regimes, but they should not carry sole responsibility for resolving contested constitutional choices. The rights to privacy and data protection act as an anchor. New laws built around the economic use of data should not quietly supplant the protections expressed through the GDPR. Rights must inform the balance rather than appear only after conflict has hardened into litigation. The chapter closes with a complex rather than pessimistic picture. Mandating legislation can legitimize processing, and specialized rules can complement the GDPR. Yet every mandate must fit the regulation, survive fundamental rights review, and function coherently inside a crowded regulatory system. The GDPR's apparent solidity is therefore more contingent than it first appears. Its practical meaning depends on the instruments around it, the institutions enforcing them, and the normative balance adopted when their purposes collide. The central warning is that legislative language alone cannot prevent data protection from being diluted by an expanded data exploitation agenda. For me, Nolan's core takeaway, or the takeaway that I take from Nolan's chapter, is that lawful processing is a system question. The GDPR does not operate alone, and neither without prejudice language nor lex specialis can resolve every conflict. Accordingly, the next lecture turns to Article 82 of the GDPR and asks how non-material damages expose the regulation's tension between market integration and the recognition of fear, loss of control, and other lived harms.